Good afternoon, sir. Sir, are you hearing me?
Yes, sir. Good afternoon, sir. Am I audible, sir?
Good afternoon, sir. Good afternoon, sir.
Fine.
Just 2 minutes, sir. Waiting, sir.
Sure, sir. Sure, sir.
Okay. Good afternoon. One and all person here. Today's webinar title on IPR. Our chief guest for Arun Kumar. Arun Kumar has more than 5 years of experience in IP and entrepreneurship field. He had filed in 4 patents on his own and helped in drafting more than 20 Indian patents. He holds 4 copyright registrations for the academic works developed by him. His possession extends to 1 design registration grant too. He has served as IP and entrepreneurship experience is more than 20 institutions through guest lectures, workshops, and webinars. He is recognized as expert member representing an IPR domain in institutions, Innovations Council of PAC at Polytechnic College, Rajapalayam. His thirst of getting expertise in IP and entrepreneurship field made him to successfully complete 10 online courses on IPR and entrepreneurship and move platforms on the learning skill continuously. His area of interest in part-time Anna University, the experienced team leader at Toyota Assembly in India Private Limited Chennai also, and then ME Energy Engineering. They graduated from the National Engineering College Koilpatti with a distinction topper badge, and then convener of the Innovation Council in RIT, IPR cell in charge, and the Entrepreneurship Development Cell in charge also. The session hand over to the special guest, Arun Kumar sir.
Thank you, sir.
Sir, Arun Kumar
Yes, sir.
sir.
Thank you, sir.
Okay, sir.
May I start the presentation, sir?
Okay, sir. Start it, sir. Students, sir, let me join in.
Yeah, let
later,
them
sir.
join, sir. No issues.
You
No
can
issues.
start it, sir.
Yes, sir.
Okay, okay, sir. Thank you, sir.
Yes, hopefully, my screen is visible, sir. Right? Yeah, okay, fine. So once again, good afternoon, all. So in this session, what we are going to discuss about is all about IPR. ஸோ இப்போது ஐபிஆர் பொறுத்த வரைக்கும் பார்த்தோம் அப்படின்னா we are going to discuss the basics of IPR and what are all the different types of IPR, and if a person is going to start a business, what sort of IPR he can prefer at the early stage. So this is what we are going to have a discussion in this presentation. So before getting into the content, I would like to thank SCAD College of Engineering Technology Management and my own institute management for providing this platform to deliver what I have learned in the past 5 to 6 years related to IP, and to share all those steps with the audience. So, and also I would like to extend my sincere gratitude to my fellow faculty member, Mr. M. Santana Marudabandian, so who is also a part of preparing this PowerPoint presentation. Now we'll get into the content, and formally before getting into the content, I would like to have a small disclaimer. So for the purpose of delivering the content, I have used various examples in this entire presentation, and I have used various names and logos of brand and various companies. And I would like to disclaim that the purpose of having those logos or brand names is just to make the concept to get a better understanding. So not to promote or demote any of the brand or the companies. So with this insight, let us get into the content. So as I told you earlier, this is going to be the agenda for us, and adding to this agenda, I'll tell you if we are going to start a business and if you are going to move towards an entrepreneurial track, what are all the suitable IPs that will help us so that we can make our entrepreneurial track into a successful way. So apart from these five agendas, in between we'll be discussing on this entrepreneurial aspect also. First, I request all the participants to be interactive because ஐபிஆர் அப்படிங்கிறது பார்த்தோம் அப்படின்னா நம்ம இந்தியாவில் இந்த பாஸ்ட் ஒரு 8 இயர்ஸ், less than 10 years வந்து பார்த்தோம் அப்படின்னா ஒரு நல்ல ட்ராக்ல போயிட்டு இருக்குது. அண்ட் நம்ம ஐபி ரைட்ஸை பொறுத்த வரைக்கும் பார்த்தோம் அப்படின்னா the entire country we are lagging a lot. So because all those lagging is because of the lack of awareness. So இந்த ஐபி ரைட்ஸை பற்றி ஒரு பெட்டர் அண்டர்ஸ்டாண்டிங்கில் புரிஞ்சுக்கிறதுக்கு I would like to request all the participants to be active throughout the session. So we shall have a discussion and either நீங்கள் unmute பண்ணி சில கொஸ்டின்ஸுக்கு ஆன்சர் பண்ணலாம் or you can use the chat box for giving your response. Okay, fine. So what is meant by IPR அப்படின்னு பார்க்கறதுக்கு முன்னாடி just a question to all the participants. இந்த presentation இப்போ பார்க்குறீங்க இல்லையா அந்த ஸ்லைடில், towards left of the presentation, what is that monument? Can I get the answer? What monument is that?
Sir, excuse me, sir.
Sorry, sir. Yes, sir.
Sir, அங்கே பார்ட்டிசிபேட் பண்ணிட்டு இருக்காங்க சார்.
Sorry, sir.
போயிட்டு இருக்கு சார்.
Oh, mute mode போயிட்டு இருக்கு. Okay, fine, sir. If possible, yes, sir. Yes, sir.
இல்ல யூடியூப்லயும் லைன் போயிட்டு இருக்கு சார். அதுலயும் பார்ட்டிசிபேட் பண்ணிட்டு இருக்காங்க சார்.
Yeah, okay, fine.
யூடியூப்.
Yeah, fine, sir. Fine.
Okay, sir.
So if possible,
Okay, thank you, sir.
the participants can give a response in the chat box also. Okay, fine. We'll get into the content. The first one is you can see a monument in this presentation slide, right? Can anyone tell what is the monument in the left side of the presentation? You can use the chat box or you can unmute. What is the monument in the left and right side of this presentation? Can anyone? Yeah, okay, fine. So probably you'll be knowing, right? So the left side, towards left side of this presentation, it is Tanjore Big Temple, and towards the right side of the presentation, it is Taj Mahal. And obviously, we know that once if we think or talk about these two monuments, the persons who comes into our mind, or if we think about Taj Mahal, the first person who comes into our mind is Shah Jahan. And if we think about this Tanjore Big Temple, obviously the person who comes into our mind will be Rajaraja Solan, right? See, why I have shown this images in this presentation is now think the purpose of constructing a temple is to worship a god, but most of the people doesn't know who is the main god in this Tanjore Big Temple, right? Most of us doesn't know the actual main god in this Tanjore Big Temple is Pragadiswarar, Lord Pragadiswarar, right? So why I am telling here is that the purpose of constructing a temple is to worship a god, but most of the people doesn't know which god stays in that temple. But if we think about this Tanjore Big Temple, we can easily able to recognize the person who constructed the temple. So instead of the Lord who is residing on this temple, we are able to quickly identify the person who constructed this temple. So that is the worth of a property. ஸோ யூ வுட் ஹவ் திங்க் இல்லையா, இப்போ ஒரு ஒரு பெரிய கன்ஸ்ட்ரக்ஷன் நம்ம நடத்த போகிறோம் அப்படின்னா தட் கன்ஸ்ட்ரக்ஷன் ஆர் தட் ப்ராப்பர்ட்டி வில் கிவ் ஐடென்டிட்டி ஃபார் த இண்டிவிஜுவல். இன் அ சிமிலர் வே, இஃப் வி are going to create any property, even after our lifetime, that property will give us the identity even after our death, right? So that is the importance of property. Okay, now yes, now think about this scenario. So probably you all would have went to market and known, you would have known about the price of onion, right? Presently, we will be purchasing the onion at a price of rupees 30 or 40 per kilogram. So probably around 2 to 3 months back, we would have seen the price of the onion. It went to a peak. It was around 120 or 150, somewhere in the range, right? So think, onion is a basic commodity, and it is an essential commodity in every individual household's cooking. Now think, when this onion price have reached a peak, what was the result? See, this was the result. Lot of people were there. They have started to steal onion in bags. So they stolen the onions in terms of hundreds of kilogram, right? Now once again, I would like to stress here, onion is a tangible property. What is meant by tangible? We can touch and feel that property, right? So all those stuffs can be called as a tangible property. So an onion is a regular commodity which is used in every day of every individual household. When price of that a well-known onion have reached a peak, it arise to a situation that it is being stolen in large amount. Now think about an intangible property. Onion is a tangible property. Our intellect. Now think about the scenario for an intellectual property. So if you are not going to protect your intellectual property, definitely there will be a chances that someone will steal your property. So that is how this IP rights comes into picture. So whatever the property we are possessing, we need to have the complete right over the property to protect the property legally. For example, consider this onion. If someone is going to complain a case that around 2 kilogram of onion from my shop have been stolen by someone else, so what the police will obviously record? They will be in need of evidence. So evidence in the form of CCTV footage, or evidence in the form of someone who has probably a forensic report, whatever it may be. So they will be in need of evidence to prove that the 250 kilogram of onion was stolen by someone. In addition to that, you as a complainant have to prove that the 250 kilogram of onion belongs to you. So that is how the IP right is. So to protect all your intellectual property, that is called intellect. So once again, we had a basic understanding what is the purpose of protecting the property. Now, what is an intellectual property? As we discussed earlier, intellectual property is nothing but any kind of property or any kind of invention or any kind of artistic or dramatic or whatever it may be. All those stuffs which comes out of our intellect will be calling those stuffs like as intellectual property. So to put it in a simple way, any property that comes out of human intellect can be called as an intellectual property. Now what is meant by right? So right in the sense, the legal right to protect your intellectual property is called as IP rights or intellectual property rights, or shortly it is called as IPR. Okay, so according to the agenda, I guess we have to understand what is meant by IP, what is meant by IPR. Right? Now coming again, what is the benefit of intellectual property? Before getting into the benefit of intellectual property, I would like to say that if you own a car or if you own a house, someone comes and asks, are you the owner of this car? Important to prove that we are the owner of the house and the car. What are the qualities? For example, consider a car. Someone to ask, who is the owner of the car? And you are saying that I am the owner of the car. He is asking you to prove that you are the owner of the car. What is the evidence for that?
உனக்கு சரி என்ன சரிதான் விடு நல்லது எது
whatever you can be able to get that in a large number. What is the evidence you will be having? Okay, fine. So obviously you'll be knowing, right? The evidence that you will be having is your registration certificate, your RC of the vehicle. In a similarly, if someone asks who is the owner of the house, and if you are saying that you are the owner of the house, and if someone asks to prove that legally that you are the owner of the house, so obviously we will be in need of producing the property deed, right? The deed of your house. So what I'm trying to specify here is that if you want to prove that any property belongs to you legally, I'm once again stressing the word legally. If you want to prove that any property belongs to you legally, you will be in need of any documentary evidence. So those documentary evidence is not only required for a tangible property which you can feel and touch, but it is also required for an intangible property which comes out of your intellectual work. So that legal rights will be given through this intellectual property rights. So ultimately, the IP rights will facilitate the inventor in this way. That is, if you are having a home, what are all the steps you can do? You can own the home, you can sell it, you can stay in the home, you can lease it, you can rent it, or even you can demolish it. Whatever you want to do, you can do if you're having the complete rights over the home. In a similar way, if you have the complete legal right over an intellectual property, you can sell it, you can own it, you can lease it, you can license it, or whatever you want to do. All those steps will be facilitated to you legally, provided you are the complete owner of that intellectual property. So that is what the intellectual property gives you as an inventor when you hold the right of the property. Now we have seen what is meant by property, what is meant by intellectual property. Now what is the meaning for intellectual property rights? Now we are going to the fourth agenda, that is need for intellectual property rights. What is the need of intellectual property rights? Because before around before 10 years or back, India was not focusing on this intellectual property rights, not even 10 years. So as I told you earlier, around 7 to 8 years, in this past 7 to 8 years, that too in academia, in the past 5 years, the people have started to talk more about this intellectual property rights. What is the need? So there are various needs for going with this intellectual property rights. So at present, we'll have a small brief on some basic need for this intellectual property rights. The first one is obviously you can prevent infringement by your competitors. Infringement in the sense it is a copying. So copying the term, it is legally in term of IP, it is called as infringement. So you can avoid infringing. For example, consider you have been asked to submit an assignment by your faculty, right? So you have written, you have referred various sites, you have referred various sources, and you have came up with a nice assignment. Okay, before your submission, your friend knowingly or unknowingly, or you would have given for your friend for reference, you are giving your assignment to your friend for reference, and what your friend does is that he copies as such your assignment, and before submitting your assignment, he or she is submitting his or her assignment to the faculty member. Now the faculty member will be um, seeing the assignment, and she or he had given the maximum mark for your friend. And once after you are submitting a day later, the faculty member once again refers to the previous submission and says that you have copied your assignment from your friend. Now what think yourself in the situation? See, your friend, you have believed your friend and you have given your assignment for his reference, but what he did is that he or she had did is that copied the assignment and submitted earlier before you and got all the credit. Now how you will be able to prove your faculty that your assignment was written first by you? That is, the assignment which was submitted was first written by you. So there is only way, you cannot prove that with the help of the hard copy, right? So you need to have some documentary evidence. Probably you would have scanned your assignments and sent the same to your friend through WhatsApp or email, and that date will help you to prove that the assignment was first written by you. So, and all these steps is called as infringement. If you are having any IP rights, this IP rights will help you to prevent your competitor from infringing your inventions or your intellectual works. So that is the first need of this IP rights. And second one is, you, it will be giving you the complete right legally, as we discussed early. So if you are owning any intellectual property right, you can own it, you can sell it, you can lease it, you can license it, or you can even destroy it. Whatever you want to do, you can do all the stuffs legally, and that rights will be given through this, or it will be provided to the inventor through this intellectual property rights. And next one is, it obviously minimizes the needless investment. Now think about the present COVID-19 scenario. So you all will be knowing that India have used two major vaccines. One is Covishield and Covaxin. And Covaxin, it was invented by Bharat Biotech in Bangalore, and Covishield was licensed by Serum Institute in Pune. Now think about this licensing. So what Serum Institute have done, obviously they would have tried for inventing a new medicine. Probably they couldn't have achieved in inventing a new medicine. Instead what they did is that they licensed the Covishield or the Covishield formula from Oxford University, and they have started manufacturing in India and circulated across the country and as well as to the other countries also. Now through the licensing, what Serum Institute have done is that they have minimized their needless investment in R&D. So those kind of steps can be facilitated with the help of these intellectual property rights. And next, it improves the innovation index of a country. I'll tell you what is the innovation index and what is the position of India and innovation index in the next slide. And next one is, it helps you to provide a licensing agreement to others, which we discussed earlier. And last, the ultimate purpose of any kind of IPs or any kind of property. If you are going to buy a land, what is the purpose of buying a land? Either you are going to construct a house, or you are going to resell it. Whatever it may be, ultimately the end outcome of that property owning will be money. In a similar way, all the intellectual property will also give you or provide you this monetary benefit, right? So these are all some basic needs of intellectual property rights. Once again, I'm stressing here that these are all the not only the need, there are still some other needs I have compiled and restricted to this six basic needs of this intellectual property, right? Now next, as I told earlier, what is meant by global innovation index? So probably you would have heard about WIPO, World Intellectual Property Organization. So what is meant by World Intellectual Property Organization is that they are the administrating body related to this IP rights across the world. So in India, to administrate IP rights, we are having various offices. For example, to administrate copyright, we have Copyright Office in New Delhi. And to administrate the semiconductor layer protection, we have SICLDR office in New Delhi. In a similar way, to protect or administrate this patent, design, geographical indication, trademark, we do have administrative office in various locations. So in a similar way, to administrate all these IP rights across globally, we are having a single organization under the wing of United Nations organization, which is called as WIPO, World Intellectual Property Organization. Now, what this WIPO does is that they rank all the countries or a part of the world. They'll be ranking on various steps, and that ranking index is called as Global Innovation Index. So every year they used to release this ranking, and you can see the position of India. You can see India is ranked at the 46th spot in the Global Innovation Index 2021. I'm sorry. Um, can you mute yourself, Mr. Aravind Ebenester? Or sorry, uh, could you mute, please, Mr. Aravind? Uh, Mr. Aravind. Yeah, okay, fine. I'll go ahead. Yeah, okay. Now you can see the ranking position of India in this Global Innovation Index 2021. We are at 46th spot. Yeah, thank you. Thank you, sir. We are at 46th spot, right? Now, see, we used to compare our country with China in various sectors. Like, see, in this Global Innovation Index, you can see the position of China. They are 12th spot, and Swiss is ranked at first spot, followed by Korea and other countries, Singapore, right? Now, why I have shown this presentation here is that uh, does it mean that India lacks in innovation? Obviously not. We do have innovation, but we are lagging in this protecting in terms of IP rights, right? Now, the ranking of our country in the year, if I'm right, 2014 or something, we were around some 72nd spot or somewhere. Now, within the span of around 5 years, we are able to reach this 46th spot. But still, we need to have to go a long way, because India is the country with largest population of youngsters, and the average age of India, as per UN, is it is around 28. Now, this is the right time to use this young population effectively. If we, the country, not going to use the present young population effectively in this situation, definitely we cannot utilize the same resource in future. So probably you'll be knowing about Japan, right? After Second World War, they were able to make their country or position their country in top 10 global economy. The sole reason is it is because of their human resource. India is also having a rich human resource. In spite of having 131 plus crores of population, we are still unable to make at least in top 20. Now, this is the right time. If every individual, every academia is going to work towards protecting their IP rights, which in turn will help the country to come to the top 10 position of this global innovation index. So, if we as an individual going to contribute and work towards this IP protection, definitely we can contribute as a whole for the entire country, so that the country reach a decent position in this global innovation index. So we need to effectively utilize this present young population. Now, once again, as I told clearly, India doesn't means that in India there is no any innovation. We do have innovation, we do have quality innovation, but we are failing in awareness. We are lagging in awareness to protect our intellectual property. For proving the same, I have taken a statistics here, which also I have took from this World Intellectual Property Organization. So this is the statistics of India. Towards the left side, it is statistics of India, and towards right, it is the statistics of China. You can see in this bar chart, it is classified into three different colors: a dark green, orange, and a light green. Dark green indicates the residents of India filed patent in India. That is, Indians filing patent in India. And orange indicates that any non-resident filing patent in India. That is, apart from India, someone else is going to file patent in India. And the third category is a person in India filing a patent in some other country other than India. So these are all the three different colors indications here. Now we'll focus on the one part, that is Indians filing patent in India. You can see by the year 2020, probably you can follow the cursor which I am showing here. You can see by 2020 the number of applications, that is patent applications filed by Indians in India, is around 22,000 or something. In the same time, you can see towards right, the Chinese in 2020 they have filed almost 14 lakh patents. They have filed 14 lakh patent applications. See, we have filed just 22,000 in the same period of time. Chinese, those who have filed patent in their own country, that is in China, the number of applications is around 14 lakhs. This is how we are lagging. And once again, to prove that the quality of the filing a patent is equal in both the country, I would like to add to an another statistics. Here you can see the bottom one shows the grant status. Here you can see the number of patents granted in India filed by Indians in the year 2020 is 5,000. At the same time, you can see the number of patents granted in China filed by Chinese is around 4,20,000 or 4,50,000 something. See, for processing a patent application, it will take around 3 to 4 years on an average. Depends upon the application. It may sometime it may take around 6 to 7 years or more than that, or sometimes it may take around 2 to 3 years on an average for processing a patent. For example, if I'm going to file a patent on the same day in the year 2022, I may get the result around 2025 or 26. So why I'm telling here is that you can see this statistics. In the year 2020, India had received a grant of 5,000 patents, for which the application would have been filed around 3 to 4 years back. Now, see, 3 to 4 years back, we can take the a year as 2017. In 2017, India have filed around 15,000 patent applications. Probably among these 15,000 applications would have been processed and the grant status would have been known in the year 2020. Once again, it is an approximate number, not an exact number. See, in 2017, we have filed 15,000 applications. Until 2020, we have received a grant for 5,000 applications, which approximately indicates us that one in every three applications filed by Indians in India are being granted with patent status. Now we'll compare the same with China. In 2020, the number of patents grant is around 4,20,000. Now we'll go to the statistics in the year 2017. Here you can see the number of applications filed in the year 2017 is around 13 lakhs, and the grant is 4,20,000 in the year 2020, which also clearly indicates that one in every three patent applications applied in China by the Chinese are receiving a grant status of patent. So both the statistics clearly expresses that the quality of patent in India and China are same. One in at least every three applications are being granted with patent. But where do we lag is that we are lagging in number of applications filed. We do lag in awareness, and that is what it is getting reflected in the global innovation index of the entire country. So why I have shown the statistics is that we, the academicians, we, the students, we, the research scholars, we are completely involved in any kind of research activity during the course of our period. We are involved in doing projects. We can also file a patent for our projects. So once again, if you are going to become an entrepreneur, and if your entrepreneurship is towards a technical path, the first thing you can go with is filing a patent for your invention. And the government of India in the year 2019, they have made an amendment that related to startup. If you are a registered startup and if you are going to file a patent application for your invention, your application will be processed within a year. The result will be known to you, either your invention got grant or rejected within a year. And they have reduced the filing fee for patent by one fourth. Yearly, for filing a patent through a startup, it was around 45,000 or something if you are going to file in physical mode. And present, they have reduced the price to 8,900 for physical filing, which includes a fast track publication. And if you don't want to opt for fast track publication, your cost of filing is 5,600 if you are going through e-filing. So this is the efforts, or this is the provision the government of India have given for an entrepreneur if he or she is going to file for a patent through his or her registered startup. So you can avail this facility, and with a, a money spent of 5,600 rupees for e-filing, and if you are able to draft your own patent, you can go for this filing, and within a year you will be getting a result. So positively, if your invention is getting a grant, then your entrepreneurial track will be towards a massive success. Now, once again, relating to the agenda. So we have understood what is an IP, what is meant by IPR, what is the need of IPR. Now we are getting into the next agenda, the different types of IP rights, and parallelly we'll be trying to correlate in what way these IP rights is going to help towards the entrepreneurial track. So in India, totally there are 8 different types of IP administrative systems, as I told early, and I have presented here 7. And the 8th one is plant variety and farmers right protection. So patent, trademark, copyright, industrial design, geographical indication, trade secret, and semiconductor layer protection or integrated circuits. I have shortly written it as IC. And the last one is plant variety protection and plant variety and farmers right protection. So these are all the 8 different types of IP rights administrated in India. Now, in this forthcoming duration of this presentation, we'll be discussing what is meant by patent and all other stuffs with a special focus on patents. Because we from technical background, we can have a more focus on patents so that this right will help us to get a better benefit in our entrepreneurial track. Now, first one is patent. So obviously, what is meant by patent? Some of you would have known, right? So patent, it is given or it is meant for any kind of invention. So in, as I told you early, in India we are having 8 different types of IP system, and one among them is patent. And these 8 different types of IP system is meant for different kind of intellectual work, and patent is meant for any kind of inventions, or it is meant for any kind of innovations, right? So patent is a documentary form, and it is a documentary legal right given for an inventor for an invention. So the total period of grant of a patent is 20 years. Okay. Now, what for the patent will be given? As we discussed early, it is given for an invention, and that invention can either be a product or it can be a process. So either it can be a product or it can be a process. Process in the sense, for example, consider we are sitting on a chair or a table, right? Now consider the cost of production of the chair or table or put together. So consider the cost of production, it will be around some 2000 rupees or something, right? Now you are coming up with an invention, or you are coming up with a process. With the help of the process, you are able to manufacture a same chair and table without affecting the quality, without affecting the appearance. With the same resemblance, you are able to manufacture a similar product at a cost of 1000 rupees. Now, this process can be patented because you are bringing an economic significance in production cost of a product. Yearly, it was 2000 rupees for producing the product. Now through your process, through your invention, the cost of production have been brought down to 1000 rupees. Now this reduction in production cost involves the inventive step or novelty in your process, and this process can be patented. So in India, the patent is given for invention, and that invention can be either a product or a process. See, I have shown an example here, right? Here you can see this. It is actually a shovel. It will be called it is called a shovel, right? You would have seen this shovel in many construction areas. The purpose of shovel is to lift a weight from one place to another place. Now think yourself handling this shovel. Now I am a right-hander. Now my right hand will always stay in the handle of this shovel, and my left hand will always stay in the middle of this entire stem. Now think yourself handling this shovel. Being a right-hander, when I handle or use this shovel, most of the weight will rest on my left hand. And if I'm a left-hander, vice versa, most of the weight will rest on my right hand. Now this is a problem. Now, to address this problem, a small invention or innovation has been made. A wheel is attached to the shovel. Now, what I can do, I can use both my hands on the handle. I can easily lift the weight, I can roll it with the help of this wheel. I can shift it from one place to another place. This is a simple idea, and it is an invention, right? Or an innovation, a small improvement. Now this has been granted patent in US. So why I have represented this image is that patent is always not a big deal. If you are able to present your invention based on the legal requirements of the patent act, then if it is satisfying the examiner, your invention can also be received a grant status of patent. Now, as I told you earlier, patent in India, it is given for either a product or for a process. Now, the product can be either a tangible or an intangible one. As I told you earlier, tangible is you can touch and feel, and intangible or non tangible is you cannot physically touch and feel. So, I have shown an example here, right? This is an example related to cricket. So, towards the top of this presentation slide, you can see this technology. It is a ball tracking system, or it can be called as a hawk eye technology. The purpose of this technology is to improve the accuracy in leg before wicket decision. Now, this Hawkeye technology or ball tracking technology, it is not a tangible one. We need this technology to be felt with the help of a monitor or with a computer system, which we cannot feel or touch physically, right? So that is an intangible invention, and it has been granted with a patent. And similarly, you can consider this LED stumps. Now, LED stump is also a cricket application. Now you can touch and feel the LED stump, which is a tangible one. So why I have represented here is that to get a better understanding that patent in India, it is granted for a product or for a process, and that product can be either a tangible one or an intangible one. So there is always a myth that a patent will be given for a product which is physically available before us. It is not so. So you can get a patent even for an intangible product also, right? It can be a technology. So, going further deep into this pattern, just for your information, it has been said that the first ever patent in the world was granted for a device which is used to transport marble. In early days, we'll be saying, obviously, we have seen the in previous slides, Taj Mahal. So, all the monuments yearly and the rich look monuments were constructed with the help of marbles. So it is always difficult to handle and shift marble from one place to another place. We need at least two manpower based on the weight of the marble, right? So in order to make that work simple, in 1421 there was an invention which is called as a bark with a hoisting gear, which is used to transport the marble, and that was the first ever patent granted in the world. And it was the first ever set patent. Probably there would have some other thing also. So as far as I have referred, so I was able to see this as the first ever patent granted in India. I'm sorry, world. And related to India, the first ever patent granted in India is for an efficient punka pulling machine. So what is actually punka means? Probably you would have seen during the kingdoms, during those olden days, behind the throne of the king, there will be two persons standing and they'll be waving off for the airflow, right? And that device is called as punka. So they will be manually waving off. So what this person George Alfred Deepening have came up is that he came up with an automated system for effectively pulling this punka machine, and that is the first ever patent granted in India in the year 1856. And this is what the patent draft which he had drafted on his own, and this is the design of that efficient punka pulling machine on different views. So just for your information, so the first ever patent granted in the world is in the year 1421, and for India is it is 1856. Now, finally coming to a conclusion or coming to an understanding, a patent is nothing but it is a legal agreement between the government and the inventor. Patent is an exclusive right. Not only patents, all kind of IPs are called as exclusive right. Exclusive in the sense, if I have came up with an invention, then I will be having the complete rights. The government is giving me the complete legal rights over the invention against the remaining 130 plus crores of people in India. See, now think about this covaxin. Bharat Biotech have invented, and no one else in India they are able to manufacture, right? Probably if they are able to manufacture, then Bharat Biotech would have licensed it. Now, the reason why the government is giving this exclusive right for an inventor, for example, consider I have come up with a novel invention, and the government have given me the grant of that grant of patent for that invention. Now I am able to restrict the remaining 131 plus crores of people in India to use without my permission. I can restrict the entire people. Now, what is the purpose? See, the invention which I have found or invented, it is meant for at least, or consider that invention is required for at least 60 crores of the people in India. Now, the government is giving the complete rights to me. Now I'm restricting all the 131 crores of people, including that 60 crore of people who are in wanted of that invention, to use it without my permission. I'm restricting them, right? Now, what is the government itself? It is giving me the right to restrict others. The reason is that if the government is not giving the right to the inventor, next time the inventor won't come up with a new invention. The logic is so simple. Your faculty member is asking you to write an assignment and submit it on some day. You have sincerely written the assignment and you have submitted it on time. Now your friend, he is also writing an assignment, and the same assignment has been submitted a week after the deadline. Now the faculty member is giving you also 20 marks, and your friend who submitted 1 week after deadline also 20 marks. Both the persons are given equal credit. Now obviously, what your mindset? You have submitted it on time, you are also given 20 mark, your friend also have been given 20 mark. Your mindset will be, next time why should I submit it on time? So whatever the time I'm going to submit my assignment, the faculty member is going to give the same mark for all the people. Then why should I submit it on time? That will be your mindset, right? In a similar way, if an inventor is not recognized with a patent, or if he or she is not given with a right, next time I won't come up with a new invention. So that is why the government, in spite of that invention is needed for most of the people in India or most of the people in that particular territory, the government still grants the exclusive right to the inventor who invented it. So that is the advantage of this patenting. And we have came to the core part of this patent. So for your invention to receive a status of grant of patent, your invention has to be satisfying three criteria. Those three criteria are: your invention should be novel, there must be an inventive step in your invention, or it can be also called as non-obviousness, and the third criteria is industrial applicability. If these three criteria are satisfied by your invention, then your invention can be given a grant status of patent. Now, he is the person who invented the LED stumps. Now, in his patent document, he had specified that his LED stumps is 1 by 1 lakh second of accuracy, of 1 by 1 lakh second of accurate. So that is what he had specified in his patent document, and no one else in the world are still able to prove or provide a better stump which is having a more accuracy. Now, he is an Australian engineer, and I just surfed in the net. So what is the benefit he is getting out of the patent rights through this LED stump? What I was able to see is that he is getting, or he is getting a benefit of nearly around 20 lakh rupees for a pair of this LED stumps. Pair in the sense, for a striker and the non-striker end, along with 6 stumps and 4 bails. So around 20 lakh rupees. You think about the benefit, the monetary benefit what he is having through his invention. So that is why, if you are going to enter into an entrepreneurial track, you are having any novel invention, then if your invention is being granted with a patent, then your entrepreneurial track will be in a complete successful way. Either you can manufacture your own invention, or you can sell it to someone else, or you can license it, whatever you want to do. So ultimately you will be getting the benefit, and you will be successful in your entrepreneurial track, right? So For an invention to receive a grant status of patent, it has to satisfy three criteria as we discussed earlier. That is novelty, non-obvious or inventive step, and next one is industrial applicability. Now let us have a small brief. What does these three stuffs means? Novelty. The thing is so simple. It must not be known to anyone else in the world. See, I have shown an example here, a gem clip and binder clip. So both these inventions are meant for holding a bunch of paper, right? So before this gem clip and binder clip have came, earlier the bunch of paper were held together with the help of a thread. So probably you'll be knowing. So the the problem with that thread is that you need to pierce a hole on the paper and you have to bunch it. Now that is the problem. To overcome this problem, they have came up with this novel idea, gem clip. So without piercing the paper or without damaging the paper, we can use this gem clip to hold a bunch of paper. Now once again, the problem with the gem clip is that if you are keeping the gem clip on a paper for a long period of time, obviously the rust may be forming and it will damage the paper. And second thing is that you cannot hold a more number of papers with the help of this gem clip, and that's how this binder clip have came. See, there is something a newer thing from the previous invention that is called as novelty. It must not be known to anyone else anywhere in the world. So that is novelty. The second thing is inventive step or non-obviousness. Non-obviousness in the sense means it must not be a mere improvement. For example, consider the same gem clip. As I told you earlier, the problem with the gem clip is that if it is been kept for a long time, there are chances for rust formation on the surface of this gem clip. So obviously, I'm a manufacturer of gem clip. I have came up with a novel thing is that to overcome the problem of rust formation, I have started painting on this gem clip and started to sell on the market the color binder clips. Now it is novel. No one else in the world have thought about it. I have thought, I have think about it, and I have came up with this color clips, but still it is non-obvious. So I'm sorry, still it is obvious in the sense it is a small improvement. That is not a big improvement in this, right? So the Patents Act 1970, it defines the inventive step as there must be either a technical advancement or an economic significance. So either one of these two things have to be there for an invention to satisfy the second criteria, that is non-obviousness or inventive step. So the economic significance I have already told you. To manufacture a product, the present cost is 2000, and if you are able to invent a process through which you are able to manufacture the similar kind of product without affecting the quality or whatever the stuff at a price of 1000, then that is called as economic significance, right? So that is the second criteria, inventive step. And the third one is industrial applicability. That is, your invention must be able to use in an industry, or an industry has to manufacture your invention. So these are all the three steps for which a patent to be granted for an invention. These three steps have, or these three criteria has to be satisfied, right? Now for getting a better understanding, we just go with a small example. It is completely an imagination, right? Now you imagine you have constructed a huge home with a lot of space for lawn. And now the problem you are facing is that you want to enjoy the rain in your dream home standing on the lawn, and without getting wet, you have to enjoy the rain, right? There is no option, right? And you take the scenario into deep further. In your dream home, you have to sit in the lawn space and enjoy the rain without getting wet. Now this is the problem. To address the problem, now I am an inventor. I have came up with the solution, a chair with an umbrella, right? I'm having a chair, I'm having an umbrella. I have just attached the umbrella to the chair and I'm putting on the lawn space of my home. The rain is coming and I'm sitting and enjoying. Now this is a novel idea. Now I'm going to apply for a patent. I'm going to apply an application for granting a patent in patent office. Now what does the patent office will be doing? they'll be checking your invention whether it is satisfying the three criteria, that is novelty, non-obviousness or inventive step, and the third one is industrial applicability. Now I have applied this invention for grant of patent. Now the examiner is there. Consider yourself as an examiner for this application. Now you are going to verify the three steps whether it is getting satisfied or not. Okay, fine. Now you are going to verify it. Let us see. Once the examiner is going to examine, what he or she will be doing is that they will be checking for a similar kind of product across the world in any form of e-document. Now at the end, the examiner had find two related documents. One is an umbrella and the other one is a chair, but he or she is not able to identify a chair with an umbrella. Just the examiner have collected two related inventions. One is related to umbrella and one is related to chair, but he or she is not able to collect any information about an invention with a name umbrella with chair. Now the inventor, what he I'm sorry now the examiner is going to examine whether the invention that is applied for patent, it is eligible for patent or not. Let us go with the first criteria, industrial applicability. Obviously a chair with an umbrella, it is able to be manufactured in a industry. Now it is satisfying the first criteria, industrial applicability. Now, the second one is novel. As I told earlier, the examiner is able to find a document only related to an umbrella and only related to a chair, but he is not able to find any invention which states that a chair with an umbrella. Now, the novelty is also getting satisfied. Now, the third criteria is non obviousness, which means that it should not be a mere improvement or a rearrangement. Now, what I have done, I have just fitted an umbrella onto a chair. It is just a mere arrangement. It is just a mere improvement. So now the examiner will refuse to grant a patent to me. Now, this is the scenario. Now consider we'll go into deep further to have a better clarity on inventive step. Now see, for the same problem, I'm going to come up with this solution, a chair with an umbrella, but I have made some changes on to my previous product. Now what I have done is that probably you all would have experienced in walking rain with the umbrella, right? Now the problem with the umbrella is that you cannot completely protect yourself from getting wet, right? Because the rain always not flow in exactly a perpendicular way. So based on the direction of wind flow, it will be shifting its direction, right? Now what I have done in the next invention is that I have fitted a sensor on this umbrella. Now the sensor is going to sense the direction of the wind flow, and based on the direction of wind flow, this umbrella is going to slightly shift towards that direction, so that the person who is going to sit on the chair won't be getting wet. Or based on the intensified rainfall, this umbrella spread area is going to expand by sensing how the rainfall is getting. See, I have made an inventive, I have used a technology in this. And next, the problem with an umbrella is that if two persons are going with an umbrella, one person is tall and other one person is short. Obviously the tall person will be holding the umbrella, right? The problem with a short person is that he can't completely protect himself from getting wet because he is short, and obviously he'll be getting wet. Now what I have added an another feature in this umbrella is that the umbrella is going to sense the height of the person who is going to sit on this chair, and based on his height, the height of the umbrella is going to adjust automatically. Now see, I have used certain technology to add value to my previous invention. Now there is a technological advancement. Now there are chances for this product to get a patent. Now that is all about patent. So your invention, with the help of your invention, you should able to prove that your invention is novel, your invention is non-obvious, and your invention is industrially applicable. So these are all the three things. So finally, to conclude with patent, a patent can be given for That is, in India, a patent is given for an invention, and that invention can be either a product or a process, and the product can be either a tangible one or an intangible one, right? And in the product also, it can be a single article, or it can be a cluster of article, or a machine, or an assembly. And even for a process, it can be either a composition of matter. For example, you would have seen in the recent advertisements, right? Asian Paints and other Nippon Paints, you would have seen. So they are claiming their paint to be a weatherproof and a lamination and an antibacterial paint. All these steps are an improvement to their existing invention, that is an existing product. And these kind of compositions can also be eligible for patent in India. See, you have seen the Nippon paint with the lamination technology, and Asian paints with the silver ion technology. Probably they would have got a patent for this. So they have made some a remarkable improvement over their existing product. So all these steps can be patented and protected in India. Okay, fine. And there are certain inventions for which the patent won't be granted in India, and I have listed very few among them. The first one is a natural law. It cannot be protected in India, and you can't claim a patent for an animal or a newly invented plant. And for a plant in India, we are having an exclusive IP which is called as plant variety protection. And the next one is you can't get a patent for an atomic energy, and for a computer programming, a business plan, and a method of treatment. So all these steps cannot be protected under patent in India. And a method of treatment, I would like to specify an example here. These two persons are the Nobel Prize winner for medicine in the year 2018, and they have been given Nobel Prize for their proposed method of treatment, which is called as immunotherapy. So at present, if a person is affected by cancer, then they will be treated either by radiotherapy or chemotherapy. Now, what these two doctors have suggested is that they have suggested to go for an immunotherapy. Instead of treating the cancer cells, you can stimulate the existing healthy cells so that the healthy cells will help the person to overcome the cancer. So this is a method of treatment. Now think, if these two persons have applied for a patent, and if the patent is granted for them, now think, there are a lot of people in the world are getting affected by cancer. Apart from these two doctors, no one else in the world can practice the proposed method of treatment what they have got grant of patent. So that is why in anywhere in the country or anywhere in the world, there won't be grant of patent for a method of treatment. So that is why they have been provided with a Nobel Prize. So a method of treatment cannot be granted patent in India and elsewhere in the world. Just a quick questionnaire. So as we are running out of time, I'll just go faster. See, a method of treatment for cancer, it is obviously not eligible for patent in India. A polyurethane foam coated with silver nanoparticles, yes, it is eligible for patent. A microorganism existing in nature, definitely it is not, because it is a discovery, not an invention. An automated transmission system for an automobile, yes, it is eligible for patent. A mobile phone with a stethoscope, yes, there may be some improvement, it is eligible for patent. An improved cricket ball throwing machine, yes, obviously it is a machine, it can be eligible for patent as it is having an improvement. And the last one is law of gravity, which is a natural law and proven law. It cannot be provided with a patent. So to conclude, patent, it is always not a big deal, right? Because 90 percentage of the patents in the world are given only for improvements over existing inventions. And I have shown an example here. What I have came to know is that the stem guard, so probably you will be knowing about the scenario, Phil Hughes. So while he was going for a hook shot, the ball hit his head behind his ear, and obviously within a fraction of seconds he completely collapsed and he died. And later came up with this novel helmet which protects the portion behind the ear. And I just was able to surf that this group of company have applied for this IP right for this stuff which is protecting the place behind the ear. So why I have specified here is that an invention or any kind of IP, it is not a big deal always. So if you are able to project your IP, I'm sorry, your intellectual property in a way the IP administrative system is wanted, then you can also hold the IP right. Okay, fine. So that is all about patent. Now we'll go to the remaining steps. That is a copyright, the last agenda of this entire presentation session. The second one is copyright. So copyright, it is nothing but a bundle of exclusive right. Probably you all students and faculty members would have seen in our textbook. If you are going to turn 1 or 2 pages, you can see who is the publisher, and near the publisher you can see a symbol C with a circle, which indicates that the copyright is reserved with the publisher of the book. Okay, fine. So the copyright in India, it is given for various stuffs, which includes a literary work, a sound recording, a dramatic work, an artistic work, a musical work, a cinematography. All these stuffs can be protected in India under copyright, including the computer programming, which we saw earlier, which is a non-patentable invention in India. So in India, you can protect a computer program through copyright. Okay, fine. Now, once again, and another example, probably you would have seen in the films in Indian cinemas, right? Around somewhere around 8 to 10 years back, you would have seen in the title god of that film, they will be representing only who is the music director. But in recent films, you would have came across who is the music director, who is that BGM scorer, who is the sound mixer. So all these steps have been added to the present cinema in Indian cinemas, right, as well as in the entire world cinema. So because everything is including an intellectual work, every individual person have contributed for that complete film or for the complete music of the film. So all those persons have to be acknowledged and recognized, and that is how all these different steps have started came in our cinemas. Okay, fine. Now the copyright, it can also be granted even for an expression of thought. For example, you can consider this Jungle Book. Jungle Book is just a single story, but it have came in different formats. It came as a book, it came as a cartoon, it came as a comic, it came as a film, it came as an animated film, it came as a 3D film. See, the same story is represented by different persons in their own perspective. So they have expressed in their own thoughts, and all those stuffs can be protected under copyright. And even, and once again, you would have seen this, it is before the release of film Darbar. So for the launch of that song, Darbar music, right? See, you would have seen this image. Anirudh invited Deva to his music composing room, because in the film Darbar, Anirudh have used Anna Malai's BGM. So the original creator of Anna Malai's BGM in India is Deva. So he have to acknowledge the original creator, and that is what copyright is all meant about. You have to acknowledge the creator of the original invention. I'm sorry, the original creation, right? Even the present presentation which I am presenting here have been copyrighted by us. See what we have done, we have just compiled the work, we have compiled the information related to intellectual property rights in a readable form that the receiver wants. So we have collected various informations from various places, and then and there we have acknowledged. You can see in every slide we have represented the source where we have referred, all the images and all the contents where we have referred. So we have acknowledged and we have compiled the work, and we have been received this registration certificate of copyright. See, so that is so simple. And apart from going for patent, every individual can go for this copyright registration also. And the next form of IP is trade secret. So trade secret is nothing but a company which is having a unique selling proposition. For example, you can consider Coke. Coke is in the market almost for more than 120 plus years, right? Till now the taste of the Coke haven't changed, And wherever you go in the world, you can have the same taste of Coke, and no any competitor have revealed the taste of the Coke, and that is trade secret. So if a company is able to protect the originality of that their own company's commodity or whatever the stuff, and those stuffs can be called as a trade secret. And for your information, in India there is no any legal act or right to protect the trade secret in India. And here you can see this is the original person who invented the trade form, sorry, the formula for Coke. He is John S. Pemberton, and he is a chemist. And during his period, he licensed and he sold the formula to a company which later formed as a Coca-Cola. See, they are spending lot of money to protect the trade secret. So as there is no any legal protection for trade secret in any of the legislations, they are protecting on their own with investing lot of money. So they are having lot of advanced technology to protect the trade secret of the formula, for which the uniqueness of that Coke taste comes. See, that is what called as trade secret. And even Google search engine, it is also a trade secret. KFC chicken, it is also a trade secret. And this is Madurai's famous Jigadanda. So that single firm, they are having the unique taste, and that is a trade secret. So anything that you doesn't want to reveal to your competitor or to the public, that will be protected under trade secret. And the next form of IP is, we are moving into the last four parts of IP, trademark. So any kind of sign which helps us to identify a brand or a company, and those stuffs can be protected under trademark. It can be a smell, sound, brand, signature, label, whatever the stuff. If you are seeing a car moving on a road, you can identify the company of the car with the help of the logo. That can be protected under trademark. See, all those stuffs which helps you to identify and distinguish the good and service of a particular company, all those stuffs can be protected under trademark, and trademark is meant for 10 years. And after that, you can continuously renew it indefinitely. And the second thing you have to do when you start your business is to protect your trademark, because sometimes trademark will become an identity for your company, for your brand. I'll tell you how. Before that, just for your information, so you can see some stuffs in many brands as TM and R as a circle. See, for example, consider India Gate Basmati rice. Probably now they have received the status of R circle. When a brand have applied for trademark and yet the trademark is to be granted, then during the processing time, the brand can use the symbol as TM if it is a commodity, and if it is a service, they can use it as SM. And once the trademark is being granted or the service mark is being granted, they can use the symbol as R circle. So that is the basic difference. So hereafter, if you go to any shop or whatever the stuffs you are watching, you can refer to it, either it is mentioned as a R with a circle or with TM or SM. So that helps you to give an idea. Now, as I told, if you are going to start your business, the second thing you have to do is register your trademark, because the reason is, so once again, probably you would have seen this image. So by seeing this image, we will be telling it the product name is Dalda, right? But actually the product name is Vanaspati. Now think, if we are going to a shop and if we ask for Dalda from the person, the shopkeeper obviously give only this product. But if we ask as Vanaspati, he will be asking which brand you want. Now the brand name is overtaking the product name. That is the importance of trademark. And similarly, we can see this product also. So obviously the product name is diaper, but most of us will be asking us Pampers. So if you go to a shop and ask, give me Pampers, the shopkeeper obviously he'll be giving I'm sorry, Pampers. But if you ask us diaper, he'll be asking which brand. So that is the value of trademark. So initially, if you are able to register and protect your trademark, one day or the other, when your business goes in the right way, the people will have your complete recognition of trademark, and at that time the product name will be overtaken by your brand name. And that is how the brand will help you, the trademark will help you. And once again, this is a machine, right? So obviously, if we see this machine, we'll be calling it as JCB, but the name of this machine is backhoe loader. JCB is one of the company which manufactures this backhoe loader, but the brand name have overtaken the product name. That is the value of trademark. So if you start a business, the second thing you have to do is protect your trademark. One day or the other, it will help you to have a maximizing the valuation of your company. And once again, this is the trademark status in India. In 2020, the number of application is just around 4 lakh. At the same time, the number of application filed in China is around 90 lakhs. And the grant status is around 2 lakhs in India, and grant status in China is it is around 55 or 60 lakhs. See why I have once again included this statistics here is that maybe patent it involves invention. Me we may lag in invention or something stuff. We may think about that, but what about trademark? It is just a brand name or a logo or a representation of a company, right? We do lag here also. The sole reason is lack of awareness. So India is not able to compete with China in terms of IP. The sole reason is the lack of awareness. If we started to create awareness among the entire population of the country, we can achieve a lot. So we do have steps in all the IP forms. And the next form of IP is design registration. Any kind of aesthetic look of a product, and all those steps can be protected under design registration. So for example, you can think about this Fanta bottle. Even without the label, just if the Fanta bottle is kept, we will be able to identify that bottle belongs to Fanta, right? So without the label of that company, with the help of the shape of the bottle, we can able to identify that bottle belongs to Fanta. So that is how the design registration is valued, right? So any kind of design with the help of aesthetic look of a product, and it does not need to have any kind of functional application, and all those stuffs can be protected under design registration. And design registration can be granted for a period of 10 years, and further it can be extended for next 5 years. After 15 years it will be open to public. Now once again, so here this is a Coke friendly twist bottle, and it was trialed in US university. See, in present days, when there is a mass gathering of the people, for example, say if there is any function in the home, at present most of the people will be relying on mobile phones. We won't interact much with relatives, right? So to address this problem, Coke came with this friendly twist. So they came up with a novel design of this a Coke bottle. So you can't open a Coke bottle on your own. You need help of someone else who is also having a similar kind of Coke, or you need to have two Coke bottles. So the two bottle cap have to be matched and twisted opposite so that it can be opened. Now this design has been protected. So there is not a big functional application. There is just an design. So any kind of aesthetic appearance which gives identity for your organization, if you feel, then you can protect it under design just to add value to it. See, with the help of seeing this bottle, just by seeing this bottle, most of us would have identified the brand. See, it is Induleka. Yes, because we understand that if the shape of the bottle is in this way and if the cap is having a comb like structure, then it belongs to Induleka. That is the value of design registration. Similarly, a pencil, right? Probably most of us would not know which brand it belongs to, but this pencil, most of us would have identified it belongs to Natraj because the design they have used there, a red color body with a black color line, so that indicates us to help us to identify that it belongs to Natraj. So that is the value of design. In a similar way, we could not have identified which pen is belongs to, but here you can see it belongs to Reynolds. So that is the design value. So if you start a business and if your product is having any unique shape or unique appearance, then you can protect it under design registration, which also adds value to your brand, and adds value to your company's valuation. So that is design registration. And once again, a small comparison. In India, the year 2020, we have filed just 9,000 designs, whereas at the same time, China have filed around 6 lakhs 75,000, or more than 7 lakhs of design registration. And the same period, the number of grant is 6,000 in India, and there it is around 7 lakhs. So completely we are lagging in awareness. If we are able to provide the awareness to all the people in India, we can reach a peak. And the last two type of IP, we are almost coming to end of the session. The plant variety protection, for any kind of plant which is having a uniqueness, then you can protect it under a plant variety protection in Indian IP system. For example, BT cotton, BT brinjal, all these stuffs. See, the problem with this cotton, general cotton, is that this bollworm will be affecting this cotton plant. Now what this company have come up with, that they genetically modified the seed of the cotton so that this bollworm won't be attracted towards the cotton plant, and that is BT cotton. And they have genetically transformed the seed, and they were able to market it, and they have protected it under plant variety protection. In a similar way, if you are able to prove, or if you are able to invent any new plant with unique characteristics, those stuffs can be protected in India under plant variety protection. And the last IP right is geographical indication, which is called as Puvisar Kuriyidu in Tamil, in Tamil, right? So the geographical indication, it will be given for any kind of commodity which is having a specific geographical origin. For example, Madurai Malli, Kanji Pattu, Srivi Palkova. So all these stuffs. So which is having its uniqueness of characteristics only because of that geographical origin, then those stuffs can be protected under geographical indication in India. And the period of geographical indication is 10 years, and it can be renewed after every 10 years indefinitely. And the only thing we have to note in geographical indication is that the geographical indication, it won't be granted for any single person or an individual. It will be given for uh, a group of people, or an association, or a community of people. So that is the only restriction related to geographical indication. And GIs are given for an agricultural product, a manufactured commodity, handicraft, or a natural foodstuffs. So all these stuffs can be protected under GI. And exclusively this GI will help you in export business. If you are having any interest to have an export kind of business, and if the nearby region around you is having any unique product, you can approach through an association or a group of people, and you can go for a geographical indication, and that ensures the quality of your product, which adds value in your export business. So GI always adds value in export business. And the first ever GI that was granted in India is for Darjeeling tea in the year 2004. And in Tamil Nadu, the first ever GI was granted for Salem fabric in the year 2004. And other important stuffs of GI in Tamil Nadu are Madurai Malli and Kanyakumari clove. And even after this Kanyakumari clove, the recent GA of India is for Narasingapatti Nagaswaram. So, including Narasingapatti Nagaswaram, Tamil Nadu is having totally 39 numbers of geographical indications, and then still many more GA tags are in pipeline for getting grant. So, in Tamil Nadu is the second state which is having maximum number of GA tags after Karnataka. So this is all about GI and IP rights. So probably I would have given the insight and overview of different forms of IP rights, and how those IP rights will help us to do a business when we enter into an entrepreneurial track. So with this, I would like to conclude, and these are all the various references I have referred for compiling this entire presentation. So I would like to conclude, and once again thank the management of SCADCET and my own institute for providing me this opportunity to share what I have learned in the past 6 years. So thank you all for your patience listening. And now the forum is open for Q&A. If you have any questions, you can ask so that I'll be able to clarify. Yeah. Thank you.
Thank you, sir. Thank you
Thank-
for your valuable time, sir.
Thank you, sir. Thank you.
Students, any other feedback or any other questions? Okay, sir. Anyway, the formal vote of thanks, sir.
Yeah.
Thank you,
Thank you, sir.
an opportunity here. At the same time, we have to explain in everything, especially for IPR and then how to find the patterns and everything, sir. It's a very useful and very kind action of this one. Thank you so much, sir. Thank you so much for your spend us in past 2 hours. Thank you, sir. Thank you once again, sir. Thank you, sir. Thank you so much, sir.